Welcome to Hull & Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Susanna Popovic-Montag. The podcast you're listening to will provide information and insights into estate planning in Canada from the offices of Hull & Hull in Toronto. Here are Ian and Susanna.
Hi, and welcome to Hull & Estates and Succession Planning. You're listening to and possibly watching episode 212. Well, welcome back. We've had a little bit of a blip in terms of downloading our podcasts, and you can see I'm the solo one today, but we wanted to keep the momentum going, and one of the things that I wanted to continue to discuss is problems that come out of estate administrations. Before I do that, I wanted to report out that we just finished up, Susanna and I just finished up presenting at a really interesting Law Society course. It was presented by Susanna. She was the chair of the Practice Gems seminar, and then our colleague Jordan Ayton did a seminar, afternoon seminars on powers of attorney. I got to talk about insolvent estates and some of the issues that arise out of that. But today I'm going to talk about, hopefully, and we may overlap a little bit in the insolvent estate problems, but we want to continue to sort of focus on and talk through today is, what about these estate administrations, and A, what are some of the issues to watch out for, and B, what are some of the problems, or what kind of fights arise out of estate administrations? Now, typically, most people when they come to see us would be normally coming to see us about a fight over an estate. Now, what does that mean, and what are those categories? Obviously, a challenge to the will is the most prominent one. But a lot of fights and a lot of difficulties in estates comes out of the administration of the assets themselves. And that, of course, means that once the executor is appointed, what problems arise. So we wanted to step back in terms of looking at solutions and identifying some problems. And one of the things that we did in the previous podcast was talk about glitches in estate administrations. Well, how do we avoid them? One of the ways, and we want to turn to now, is the download of information at the outset is so vital, because both at the time of giving your will and when you give your will instructions, but most important at the time of death, when you're an appointed executor, you're coming in to see the lawyer and you want to determine the assets of the estate. One of the core questions, of course, is what are the particulars of the estate assets? What do we have to deal with? And my son, who's just learning accounting principles in school, tells me all the time about debits and credits and reconciliation and all those sorts of things. Well, obviously, the credits is the key starting point when we're dealing with an administration. So, the particulars of the estate itself, talking about, trying to identify, and the executor goes out and pulls together as much information as they can about the core assets. Obviously, bank accounts, locations of accounts, bank certificates, stocks and bonds, and the like. The next thing is to step back, and one of the early stages of downloading the information is the particulars of the real estate. And this is the one issue that sometimes brings about some of the twists and turns. And that is, of course, people who die, before they die, maybe do or do not know exactly how the real estate is held. And, of course, it could be held jointly with right of survivorship with someone, between two spouses, transfers over to the other spouse, no questions asked. Or it can be held in different ways, tenants in common and so forth. Sometimes the clients don't even know that when they're telling their lawyer their instructions on how to do a will, and sometimes you get surprises. So I always tell my clients at the outset when you're giving instructions, make sure that you give me a copy of the deed, or you let me go search the deed, and we can do that now in Ontario all electronically, so it's not a big undertaking, to make sure that we know exactly how the real estate is held. Now, of course, that applies, and the same problem applies with bank accounts. And when we get the information, we want to determine whether or not they're held jointly, or they're not held in some sort of trust or some sort of arrangement that the deceased hadn't really fully disclosed to the estate trust, to the lawyer when he or she does her will. But you're a estate trustee. Your obligation is to bring in the credits. And are they credits, and how are they held, and the details of those credits is crucial. Because, of course, then you can identify whether or not there's going to be some twists and turns, whether or not an asset is going to fall into the estate or it's going to fall into a jointly held scenario. So the particulars of that and chasing down those details is important. Other assets, of course, other real estate, other holdings. We have estates where some client had a tremendous holding of gold bars, literally holding gold bars, and that was the way she felt that she would hold on to her investments. So we had to go, and it was a big undertaking in terms of trying to track down where exactly the gold bars were and so on. But there are a variety of assets that can come about. And the thing that we really touch on and make sure that we've carefully canvassed is the maybe not gold's worth something, but maybe the stuff that's not worth so much. And those particulars of those assets can be a big issue. As an estate trustee, when you're charged with the obligation, you're charged with bringing in all of the assets. And personal property, or the teacups, of course, can be at a really important flashpoint to the beneficiary. So as if I'm the estate trustee, one of the things I will typically do and tell my clients to do is, when you've got to go into the apartment, grab a video camera, do something, a still camera, take a ton of pictures, make sure you've identified the starting point. And it ties into, of course, the starting point with estate accounting. We want to start with our opening balance. Well, the opening balance, and we've seen too much litigation come over this over the years, can be all about where's the teacup, or where is that one statue that there was a mini statue, or the Royal Dalton, where are those assets? And the executor, if they're not there on the date of death, the executor can get blamed. So one way to help avoid that or reduce your risk as executor is, of course, to videotape the whole apartment or the whole house. You've got a record of what is or isn't there. And then secondly, we often will say, look, get a professional to come in and inventory all of the assets, so that nobody can say, hey, you gave Johnny the Royal Dalton you shouldn't have, the will didn't provide for it, and your answer is, well, it wasn't even there, so why are you saying I've done anything wrong? Well, litigation can ensue out of that. So these other asset categories, obviously the bank and the cash and the investment accounts, is one cornerstone of what you have to bring in, and that means sometimes going through all of the paperwork of the deceased. The second is the real estate, and that you can get some help through the searching through as I say, most in Ontario certainly you can search online for that. And then thirdly are these sort of other assets, and assets which on the face of it may not seem like important to the executor at the time. It's not worth a lot, who cares about it, but that couch all of a sudden becomes a flashpoint for tension, which is the thin edge of the wedge, which opens up other issues and which starts to bring up the potential for discord and for fighting in that regard. So when I sit down with my executors, I really hope that we try to see them as early as we can after death, and that can be literally within days sometimes, to make sure that we've got full control over the assets. So as I say, talking about the fact that I'm learning more and more about basic accounting through helping my son with homework from time to time. Those are the credits. And then, of course, the liabilities. And what do those liabilities bring to the table in terms of tensions and problems? And at my next podcast, I'm going to talk a little bit about that side of the ledger, to walk through and identify some issues for an executor, so that we can come to the table clean and ready to go without with limiting the potential for claims against me or my clients as executors. So thank you for joining me. We miss Susanna today, as always, and we look forward to seeing her hopefully back at a podcast soon. Thanks very much.
You have been listening to Hall on Estate and Succession Planning by Ian Hall and Susanna Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hall & Hall podcasts or leave any questions or comments, please visit our website at hallestatemediation.com.